Welcome to the orthoPAC podcast with your hosts Sam Dyer, Chuck Dowell, and Miles Gilbreth. Please join us as we attempt to fill in the gaps between education, current events, and real-world practice. Listeners, welcome back this week, where we're joined again by Susan Ferrero, where we continue our discussion on medical legal consulting. Susan, what about trends and future outlook? Any emerging trends in the medical legal landscape that you've noticed? A lot of telemedicine going on since COVID. The AI is a big topic. Scope of practice issues. North Carolina just passed a law, I think is HB 67. Miles just wrote it up. I haven't read your entry yet, Miles, but just passed a law where PAs don't have to have the supervision requirements they used to have and stuff. Now, that's a great thing as far as practice, but it also opens you up to some more legal doors. So, something to think about there. But anyways, what have you noticed in emerging trends with the medical legal cases?
One of the biggest things I'm seeing, and we were just talking about, was the audit trails. I think they're going to become standard with any record review, and PAs need to be aware that everything they're doing in the record is being recorded, and potentially something you could be asked about if this was a lawsuit. So
Can I just jump in real quick? A
sure.
digital footprint was what I was trying to think of. Your
Yeah.
digital footprint you leave every time you sign in. So sorry
hmm
to interrupt you.
Yeah, no, you're absolutely right. Everywhere, and it's amazing because I kind of always knew, like, oh, they can tell when you opened the record, right? They can tell when you saw the patient. It's all time stamped. But what you actually see on the front, where it's time stamped and you sign your note and it says you signed it at 3 p.m. That's there's so much more to it. I mean, they know how long you were in it. They know how long you were, what areas you were writing. They know what was written. They know where you were. Like I said, all that stuff there's a record of it. So keep that in mind. And I cannot enforce upon PAs or any provider enough to just document and document well. And that doesn't mean that you have to write a book and document every single thing. And I understand that it's very time consuming to write out a lot of things on a record, but you have to get into the habit of just documenting well, because it's the only thing you're going to have to defend yourself if your care is ever called into question. And especially the MDM part of it, you want to make sure that you are documenting and explaining your rationale and supporting it, putting differential diagnosis, why those are the things in this particular case, because that's going to help you if you get sued, or when you get sued. That's the only thing you're going to have is your record, because it's going to happen 2 or 3, 4 years down the road, and they're going to ask you about a patient and you're going to say, I have no idea who that person is, and they're going to give you your record, and you're going to have to look at your record, and that's going to have to refresh your memory, and they're going to have a story already planned out of what happened. And if your record can't defend that, then it's just left to you and your memory, and they're going to play off the fact that it's been 3 years and your memory, you don't remember. So documentation is huge. And I think that's the key takeaway for PAs, is that you just need to make sure that you're documenting really well. But again, it doesn't have to be a book. You can use dot phrases, you can use templates. Those are fine, but just make sure that you're changing the information so that it reflects the actual patient at that actual time. Because otherwise, if you go through and it's just, you can tell it's a template, and you can tell, and you see the person was intubated, yet it says they were A and O in talking, that those two things don't match. So documentation, use templates if you need to, but make sure that you're going through and actually accurately putting the information in there. But I think I got off a little bit on a tangent, but from your question was, I think, more about practice
Yeah,
autonomy and
more
things.
trends. Yeah, trends like telemedicine,
Yeah.
AI, or scope of practice like the North Carolina. But yeah, all
Yeah.
that you're saying is great information. We got some time. Yeah, I love listening to this because it's good stuff.
I love talking about it. It's something I've become passionate about, and helping PAs work toward not getting sued, right? Because it's scary, and the way things are going, the landscape is changing because administration is pushing us to do more with less resources, and they don't really care. See more people. It's more about seeing more people in less time, and we have to kind of come up with ways to get that done. And a lot of times documentation gets diminished. Our time with the patient gets diminished. These are all things that then start leading more toward getting us sued. More mistakes are happening when that's the case. You mentioned the North Carolina more autonomy, and I think that it's great. PAs are already working autonomously in most states, so I'd like to see that acknowledged. I like that it's being acknowledged. I think when we're finding a job, the struggle is real because many administrators see that supervision requirement as red tape, and then they prefer an NP because they don't have to have all the paperwork requirements. So I think it's good in that sense, but I also think it exposes us to more legal risk. It's going to be important to going forward as we get more autonomy. It's going to be important to stay current in our field, to maintain close working relationships with the MDs that we work with, and to stay humble. Just because they passed a law that says you can practice autonomously and without supervision in some states, understand that our training is not necessarily the same as a physician. It isn't the same as a physician in a lot of cases. And I mean, I know some PAs that are much smarter than physicians, but we need to stay humble and realize that we still have limitations and we have to ask for help essentially when we need it.
Well put, well said. I think that's great information, but it's great that we have the ability to do the things we're doing and that we, in North Carolina now specifically, that we're able to do things that we could do before, but now without the supervision component or whatever. But yeah, it puts like a target on your back. So when these lawsuits happen, when a plaintiff goes out, they cast a net. Baby, I mean, there'll be 3 or 4 hospitals, there'll be 2 or 3 practices, there will be a bunch of MDs, PAs, and like Susan was talking about, once they start getting into discovery, which is where they gather all the records and they gather all the documents and all that stuff, they kind of start weeding through that a little bit. And I think sometimes they have a very broad target and then they try to narrow that down. Well, PAs, the malpractice for us is the payout's not going to be as high as with the surgeon, so the target's bigger for them. But then you start talking about autonomous practice and you are the ones that made the decisions and you didn't really consult somebody, then you're it. And so you really need to know about that. And then also, I don't want to spend a lot of time talking about this, but the different types of malpractice, claims made. What are they, Susan? Claims made and there's
Occurrence.
3 of them. What are the others?
There's claims made, as personal malpractice policies. Is
Correct.
that what you're talking about? Yeah, there's claims made and then occurrence policies.
Yeah, you need to, and I'm not doing a good job talking about that because I wasn't, didn't it? It just popped up in my head. But you got to know about the different kinds of malpractice. And then if you have an extra policy outside of your practice, well, that's also a target because why do you need that extra insurance? Why do you have extra insurance? So those are all things. That's how an attorney thinks. You have to be ready for that kind of stuff.
You're absolutely right. They cast a wide net, and sometimes that has to do with the fact that they need to name everyone they can off the bat and then kind of drop people as they go along because they once in some states they can't name people after the fact. You have to name everyone that you think was involved. So that means everyone, right? The janitor's getting involved. And then they start cutting them down and saying like, okay, right, the PA, I don't see anything in the they get a PA expert who looks at the case and says, no, the PA, did not breach the standard of care. This is there wasn't anything on them. Then they'll drop the PA, and then there's maybe the nursing staff that they're looking at, and because they can name the hospital and the nurse, if it's the nursing staff, and then maybe they drop the nurse because the nurse, and then there was another doctor involved, and he gets dropped. So they drop them as they go along because they need to name them all up front. Because 6 months later, they can't say, "Oh, we we're going to now name these 2 physicians and it's the case has already been filed." You have to have that up front. So they do cast a wide net and then a lot of times people get dropped off. But, sometimes people should get dropped off and they don't. And you don't want to be in that position where you're still stuck in the case, even though you're really not that involved. And personal policies, you're right. They will go after, if everyone has a separate policy, then they go after, that's more money for them, for their client. And if you have a separate policy, one of the benefits is that you are not under you have your own attorney. So if you have your own attorney, then they're speaking on your behalf. So the defense attorney is the defense attorney for everyone and that involved in that hospital system or office group. But if you have your own attorney, and they're going to make the decisions, and if you have your own attorney, they will be making decisions. So that can help you by having your own policy. It's more money, and it's more money that they can draw off of, but you actually have someone representing just you, not the hospital or the company or the whole group, if that makes sense.
Yeah, and with the claims made and the occurrence policies and all that, I don't want to go into this because we're out of time, but everybody listening to this, check out your malpractice policy through your provider there and check out the term called tail coverage, i.e., if you leave that practice and go somewhere else, are you still covered? Something for another discussion. Susan, we're running out of time here. What parting thoughts would you like to share with our listeners?
I think I would just say, don't be afraid to practice. I don't want people to feel fear that they're going to get sued. Know that it's a possibility, but if there are ways to mitigate it. And I would say documentation is one of the biggest things. The other things that we mentioned, like having good rapport with your patients, taking time with them, and then other ways to reduce your legal risk is to speak up. Most errors are tied back to systems issues with hospitals or offices, the old Swiss cheese model. If it kind of goes through all the holes in the layers and something goes wrong, we're being asked to do more these days with less. And I think we all just need to speak up so that this doesn't happen because we're seeing an increase and we're going to continue to see an increase in malpractice suits because of the mistakes that are being made due to these systems issues. So I would say don't be afraid to speak up. And if you feel that something is unsafe or the pace or the volume is too much, because it's going to come back to you in the end. But otherwise, yeah, enjoy practicing and don't be too scared.
Yeah, I mean, just treat people like you would like to be treated. The old golden rule, right? I mean, you do that and you use good knowledge, good common sense. You should be in good shape. Mistakes happen sometimes, but just be aware that you have resources. So, Susan, I really appreciate you being on today. I wanted you to be able to give a plug for your business. And if you're looking for people, would you like to share some of that information?
I currently work just with myself. At some point, I may take on subcontractors, but I currently work for myself with my company's name is Ferrero Medical Consulting. I can be reached at susan@medlawpa.com. Medlawpa is my website. And I also want to mention that if anyone's interested in expert work or doing medical legal work or getting involved in the risk management part of it, I would suggest people join APOM, which is the Academy of Physician Assistants in Legal Medicine. We have kind of taken over it's been around for a while, but we've taken over recently with some new administration, and we're starting to offer more webinars and newsletters on legal topics and risk mitigation, with plans to roll out more education on the subject. So if it's something a listener is interested in, I would say join APOM and get involved.
Susan, thank you so much. I appreciate it.
You're welcome. Thanks for having me on.
Thank you for joining the orthoPAC podcast. We also welcome you to visit our website, paos.org, where members can download virtual conference content and get Category 1 CME. Also, if you're a non-member and you're interested in our CME content, please visit the aapa.org Learning Central